Second, I am your moderator for tonight. My name is Khairiah. I am the branding and marketing. Are going to talk about how do you make sure that equally and evenly to your loved one. So today here we have two of our licensed financial planner from Vantage Advisory. Welcome guys.
Hello, good evening.
So we have here. Hi, hello. So we have here Miss Eyvonne from Vantage Advisory from Sabah. She is based in Sabah. So and then our second panel is Miss Angel. Miss Angel is based in Sarawak office. So both of them are licensed financial planner from Vantage Advisory. So for the benefit of our audience, can you introduce yourself? Starting from Miss Eyvonne.
Okay. Hi, everyone. My name is Eyvonne. I'm a licensed financial planner from Vantage Advisory, and I hold a certificate of registered financial planner and also Sharia registered financial planner. Thank you.
Okay, evening. I'm Angel. Okay, I'm also from Vantage Advisory, and I'm based in Sarawak. So, so far I'm holding a certified financial planner and Islamic financial planner certificate. Okay, that's all for tonight. For my introduction. Thanks.
Okay, thank you, Eyvonne. Thank you, Angel. So before we started, don't forget to comment your questions in the comment section below. And then after the presentation by our panelists, they will answer your questions in the Q&A session. So without further ado, Eyvonne,
Yes.
can you start?
Sure. Okay. Hold on. Let me.
Okay.
Just 1 second. Sorry, some technical problem.
It's okay. It's okay.
Okay. So, can everybody see this?
Yes.
All right. So, good evening again. So tonight, our topic tonight is on estate planning and what are the tools that we can use. So here, basically, we'll share 8 of the common tools for estate planning. So this will give you an idea, which tools are suitable for you in order to, have a proper distribution of your estates in the best manner that you want. So I hope that after this webinar, you will learn something, okay, some knowledge on how to plan for your loved ones so that, they will not be burdened at the time when you are no longer around. Okay, so, we always, ask, how do we make sure that, our estate will be received by our loved one? So some of you might, be wondering, normally isn't my estate, passed to my family automatically when I pass away? Well, it depends on the situation because there are many factors that might affect your distribution manner and also the tools that you use for your estate planning is very essential, to make sure how your estate is distributed, to who it is distributed, when to distribute, and what assets to be distributed. So, but certainly it is not automatic because there is a legal process that which is called the administrative process that we need to follow. Okay, so let me recap, what is estate planning. Estate planning is a process of preparation and arranging during a person's life for the management and distribution of that person's estate in the event of incapacitated or death. So asset distribution can be done in many ways, okay, whether it is through a will, a trust, insurance, a charity, and many more. So which tools to use for your estate planning is depending on, how you want your estate to be distributed and for what purpose. Okay, so let's look at the 8 tools, okay, in estate planning that we are going to share tonight. So the first one is will writing, or for Muslim is Awasia. Okay, then second one, nomination, okay, assignment, power of attorney, buy-sell agreement, matrimonial assets, hibah, okay, and also trust. So these are the 8 main tools that we're going to talk about tonight. Okay, so the first one, which is a will. A will is a written document, okay, that sets out your instructions and wishes on how you want your assets to be distributed after an individual's death. So when you are writing a will, you appoint an executor, okay, to manage your estate, okay, handle your assets after death, and also carry out the wishes in your will. Okay. Additionally, if you want to include like personal preferences such as guardianship, for example, to appoint somebody that you trust to be guardian of your minor children, and also you can set some preference, like if you have aging parents or special kids that you want to have some care arrangements for that. All this you can write. You can put it inside your will. Okay, and will is not just for the rich or wealthy. Okay, regardless of how much asset or how little money you have. Okay, a will can ensure that your wishes are heard, and it states that whatever personal belongings that you and assets that you have will go to your family or the beneficiary that you want. Okay, if you own a business, okay, a will can also help to ensure that a smooth legal transition of those assets. Okay, so here's some tips. Okay, if you have a minor children or disabled children, or if you have elderly parents, or if you have a business, and especially if your assets is more than 2 million, it is advisable that you have a will written. Okay. Then next, a wasiat, which is for Muslim. A wasiat is a declaration of person made during his lifetime with respect to his property or benefit thereof to be carried out for the purpose of charity or for any other purposes permissible by Islamic law after his death. Okay, so based on a narration by Ibn Umar, the making of a wasiat is actually highly recommended by Prophet Muhammad. Okay. So as a Muslim, your assets, after you pass on, will be distributed among your heirs in accordance to Faraid law. But what about those who are, not regarded as the legal heirs? Okay, so this is where wasiat comes in. Okay, it will enable you to distribute 1/3 of your assets. Okay, for non-Faraid heirs, for example, whether they are Muslim or non-Muslim, or even to charity. So here, if you have minor children, disabled children, or if you do not have any heirs, a mualaf, which is a converted Muslim, or if you only have daughters, no son, or if you're in a polygamy marriage, then you should actually write up your wasiat. Okay, then next one, we go to nomination. A nomination is the right given to the owner, okay, to appoint a person who will be entitled to receive the nominated assets in a trigger event. So what we see very common is nomination in our EPF, in our investment like unit trust, insurance, and also ASB. So also, very common we see this and one thing I want to highlight is that the nominee of a Muslim receive the assets only as an executor, or what we call wasi, okay, and must distribute in accordance with the Islamic law. So for Muslim, if you have nomination for EPF, in ASB or in insurance, they are only the wasi. So they are not the legal beneficiaries. Okay. So next, let's go into assignment. Assignment is an arrangement where the assignor transfer his rights or benefits to the assignee. So very common we see like insurance policy, we can do assignment, and such as MRTA for our mortgage loan, where you assign your policy to the bank for the purpose to settle the outstanding loan in the event of death or incapacitated. So another situation maybe I could think of is if an elderly person, okay, who has a life insurance, where this elderly person is also seriously ill, okay, and he requires money for his treatment costs and for his well-being. So he can actually assign his life insurance policy to a trust that will give him this cash now to pay off his medical expenses during a trigger event. Okay, so here, if let's say you have debts, or if you're the head of the family, okay, it's better to do an assignment of your policy. So head of the family, why do I say head of the family? If your family, like your children or your spouse, is highly dependent on you in everything, like management of your finance, then it's good that you get somebody, maybe a trustee, to help you to do arrangement on all your management of your finance. Okay.
Sorry, Eyvonne.
Yes.
So
Yeah.
going back to the assignment slide just then.
Mhm.
So you said
Yes.
that assigner can transfer his right or benefit to the assignee. So
Yes.
and
Correct.
then who is the third party that can be signed for the
Okay. As just what I mentioned just now, the third party, like your MRTA, if you assign your
mm-hmm.
insurance policy to the bank, so the bank is the third party. Okay, and if for the elderly person, he can set up a trust. So when he
Mm-hmm.
assign his insurance policy to the trust, he can assign it to the trustee. So the trustee is the third party.
Okay.
Okay, do I answer your question?
Okay.
Okay, so next let's look at power of attorney, okay, or we call POA. It's a legal document which allows a person we call the donor to appoint another person, the donee. So which authorize the donee to act on behalf of the donor, okay, in private affairs, in his business, in signing papers, handling bank accounts, or even some other legal matters in the event of incapacitated especially. So if you have a business and if you are playing a very active role in your business, power of attorney may be a useful tool for you to appoint someone that you trust to handle your business activities. Okay, and there are two types of POA. Okay, revocable and irrevocable. So an irrevocable POA means that the donor cannot change or revoke the POA, nor his death can revoke the POA. So even it will continue after death. Okay. Then next we go to buy-sell agreement. A buy-sell agreement is a legally binding contract that stipulates how a partner's share of a business may be reassigned if that partner dies or otherwise leaves the business. Okay, so here usually we do business succession plan where there is a buy-sell agreement involved. Okay, there will be a trust deed and also a power of attorney. Okay, so there are many potential problems that can result from trigger events like death, disability, or even divorce. All of those events can cause problems for the individual who are involved in the business. It could be stressful and exhausting. So this buy-sell agreement is an attempt to avoid potential chaos should one of the partners in the business want to or need to exit the business. So here, if you are a business owner in a family or have multiple owners business, it is advisable to get this buy-sell agreement set up. Okay. Then next is matrimonial assets. So matrimonial assets are property which includes movable and also immovable, okay, acquired by husband and wife during the subsistence of a valid marriage where both parties have contributed, either directly or indirectly towards the acquisition of such property. So for Muslim especially, the terms and conditions of assets will be determined by hukum syarak. Okay, so example of matrimonial assets such as your house, okay, we call matrimonial home, okay, and also other immovable properties when you acquire during your marriage, okay, tangible properties such as cars, jewelry, furniture, intangible properties such as money, shares, cash, investment, even EPF, okay, and also gifts, okay, gifts like with substantive value, okay, from husband to wife or vice versa. Okay, so for matrimonial assets, you can claim in the event of death, divorce, and also in polygamy. Okay, then next we go to hiba. Hiba is a benevolent contract of an offer and acceptance between donor and the donee, okay, the recipient. So wherein the donor transfer the possession of the property to the donee for free without expecting any return. Okay, so the hiba is a unilateral contract. It could be revocable prior to the donee taking possession of the asset. So once it's passed to the donee, when he has the asset, then it is not revocable. Okay. Then at the point the donee cannot revoke the when it is irrevocable upon the donee taking possession of the hiba asset. So at that point, the donor cannot revoke the hiba contract. Okay. So maybe some people may ask, what if the donee die before the donor? Okay, then the assets shall be returned back to the donor. Okay, so here if you have adopted child, okay, because adopted child is not the legal faraid heir, so you can hiba for your adopted child, and if you want to give for a non-heir or even for charity, then you can use hiba as a tool for your to distribute your asset. Okay, then next we go to trust. A trust is a legal arrangement between the settlor and the trustee, whereby the settlor transfer property to the trustee for them to hold, manage, and distribute for the benefits of one or more beneficiaries. And under trust, you can actually have two types of trust: revocable and irrevocable trust. Okay, but maybe I can show you. This will be a more clear picture for you. How does a trust works? So the settlor who set up the trust, okay, will put his assets, whether it's movable or immovable assets, into this trust. We call the trust assets, okay, to a third party who is the trustee. So the trustee will hold and manage the trust assets according to the trust deed. Okay, so you can set up the trust for various different objectives. Okay, whether it is for to set up education for your next generation, for successive generations, to creditors protection, or even to settle your debts. So all of these objectives, you can have different objectives and then the beneficiary can be anybody, okay, or even a charitable organization. Okay. So here is a summary of the 8 tools that I have shared just now. It depends on your situation, and also your wishes. So different tools can help you to achieve different objectives. Okay, so to give you a better idea, why we need to have different tools. So let's look at a comparison between, trust versus will. Okay, from here you can see, what are some of the limitations that, will cannot do, but can be fulfilled using a trust. Okay, first is trust can bypass the probate process, okay, which is tedious and also avoid delays and expenses. But will you still need to go through the legal process. Okay, and then in the trust, a settlor is able to plan his wealth management during old age and incapacity, where he can to make sure to pay for his caretaker and his medical expenses. But in a will, we cannot, because it's triggered upon death. Okay, and then in the trust, the settlor is able to provide education and medical treatment to family members, for example, for their children or grandchildren, for the third, fourth generation. But a will cannot do that. Okay, and then number 4 is confidentiality, because a trust is a privacy and ownership of a privacy of distribution plan, so it will not be publicized. But will is not necessary; it could be public. Okay, and then trust is able to ensure that the income received from the investment are managed and distributed to your family members or beneficiary according to the wishes of the settlor. For example, if you want to do like charity or staggered distribution. For example, if you want to give you do not want to give one lump sum of your assets to your children, maybe you can stagger it by at the age of 24 you get a portion, by the time they get married another portion. So this can be done in a trust. Okay. Then also ability to ensure that the family's wealth will be retained and does not fall to the hands of external parties like potential former spouses, creditors, or even in-laws. Okay. Then succession planning is able to provide for successive generations. Okay. And the last one is avoidance of estate duties. If you have assets in overseas like US, UK, or Japan, okay, especially like US or UK, their inheritance tax is very high, which is 40%. So if you want to avoid the tax, you can set up a trust to do that. Okay. So I hope that here will give you some ideas, why is it important to have different tools to plan for estate planning. And then next, Angel will share on some case study to give you some examples, so you have a better idea on whether how should you plan for your assets. Okay, so I'll pass to Angel.
Okay. Thank you,
Okay.
Eyvonne. Okay, let me share my screen.
Okay, everyone, before Angel started her part, so I would like to remind again to comment your questions in the comment section. Okay, Eyvonne. Okay, Angel. You can start now.
Okay. All right. Okay. Good evening, Angel here. So this evening, I will share some case study scenario for give some idea and better understanding for all of you to have a better understanding on what the tool just now shared by Eyvonne. Okay. So before we go into the scenario, let us see what is the common issue faced without proper estate planning. Okay, first thing, majority will have the issue of asset will not distribute according to your wishes because you are not doing the will according to the distribution act. And then in the event of double tragedy, you may left the minor children without the trustworthy guardian. And there is the issue of trustworthy. Trustworthy, even though sometimes you appoint the executor or administrator and also the guardian, but how good they can help to taking care of the estate administration process and also the minor. And what happens if you have adopted children and you love the children, and how you can make sure the asset can distribute some portion to them. And then what if you want to give some of your asset for donation? And then how long will it take to complete the administration process? Well, when death occur, the asset will be frozen. So will my family have enough cash on hand for their living or medical expenses in the meantime? Okay, let us go to see some scenario. Okay, first scenario is non-Muslim scenario. The scenario here is the married couple with minor children. So Mr. A's family, Mr. A family. So Mr. and Mrs. A married, and their parents still around, both their parents still around, and there is the 3-year-old son and 5-year-old daughter. So of course they are doing their the working life, so they have building out the asset, like they have the properties and car and liquid asset like cash, uh, uh, fixed deposit, or those investment on property, investment on unit trust, share, all this, and then have a proper at the policy protection and also have the EPF funding. So if Mr. A did not do the will writing, so what happened if upon the death of Mr. A? Okay, so for the non-Muslim without the will, so the distribution will according to the Distribution Act 1958 and amended in the 1997. So according to based on Mr. A scenario, so surviving beneficiary upon his death will be spouse, parents, and children. Means that the spouse will be entitled quarter of the asset, and then parents is quarter, and children is half. So for the beside that, the EPF will follow the nomination done by Mr. A, and the insurance policy, all these will follow the nomination done by the Mr. A in the policy. Okay, so what is the Mr. A's wishes and concern actually? For him, of course, he would like the asset to be kept in his families, which is distribute those liquid and non-liquid asset to his spouse and the children. And EPF at this moment, he haven't updated. At this moment, current situation is 100% nominate to the parents. So he wished to nominate 80% to the spouse and 20% to parents. So insurance policy also, he will look into assign some policy to the parents and some to the spouse in order can taking care of the minor children. So he also have the intention and we just want to contribute 20,000 donation to the church. So the concern here is that if unfortunately event happen like death, so he will be worried he still have the minor children, and the wife actually is a housewife, so may not be able to carry out the duty as the executor smoothly, and he is the only income earner for the family. So to solve this one, this is the one that we would recommend. The proposed tools that he can utilize, first thing will be the will, because your will is the basic tools to unlock all the frozen asset. So he can using the will to distribute his asset according to his wishes. Example, like he want to distribute the asset to the wife or and also the children, and can solve the execution concern. Appoint the trustee company as the executor because they are professional, can execute the will after his decease. And beside spouse is the legal guardian, he actually shall appoint another substitute guardian who are trustworthy to taking care of the minor just in case of the double tragedy happen. He also can list his wishes or distribute 20,000 or donation to church. So the other tools he can use is the nomination, can utilize his nomination, make sure to update his EPF nomination according to his which 20% to parent, 80% to spouse, and also update his nomination in the policy to his intended nominee. He also be advisable to set out the trust. Inside the trust, you have the assignment, nomination, or power of attorney. Those tools can be used. So he can fund the trust by either assign his asset, his investment asset, or he can assign the insurance policy under the trust fund. If the death occur, he can protect the minor children education funding to take care of the family living expenses, seeing he is the only income earner, and also to provide the support to the aging parent. If during the lifetime there is the issue of coma or disability happen to Mr. A, the trustee side also can help to taking care of the medical expenses based on the trustee that list out by the Mr. A. Okay, so let's see what is the difference without the will, with will, or with the trust. So appointment of administrator or executor without the will, the appointment of the administrator must be agreed among the beneficiary, which means it will take time to agree who is the agreed to appoint who is the administrator. With the will, executor actually already appointed by the Mr. A in the will. With the trust, is under the trustee care already. So document to be applied in the district office or high court. Without the will, need to apply the letter of administration, the LA. With the will, need to apply grant of probate, is the GP. With trust, is actually bypass these two legal process. Distribution manner without the will will be according to the Distribution Act 1958. Just like just now, example is a wife quarter, a parents quarter, and the children is half of the entitlement. With the will, is based on the Mr. A's last wishes in the will, and with the trust also based on the trustee, which is the stated by the Mr. A on the witches also. So duty of the administrator and the executor before distribute the balance asset to beneficiary, it must pay off the debt, no matter with or without will. They must pay off the debt and outstanding taxes before they can distribute the asset to the beneficiaries. With the trust more than 5 years is actually creditor proof. So distribute donation to charity organization. Without the will, Mr. A cannot do that, but with the will and the trust, he can do that. And taking care of the children education and living expenses managed by the professional. Without the will, is actually cannot be done. And with the will, this one depend on how good is the executor or the beneficiary can manage the funding. And with the trust, actually is handled by the trustee, and they were based on the we just listed in the trustee by Mr. A.
Okay, Angel.
Sorry.
I want to ask the slide before. So you are saying about the administrator, who you can appoint actually as a administrator.
Okay. Appointment of the administrator, actually when they apply, they should appoint among their beneficiary, which means all the legal beneficiary like spouse and the children and also the parents.
So
They must agree among.
mhm.
Yes.
Sorry, continue, Angel.
Okay, so it means that it must be agreed among all of them. Let's say you want to appoint the wife, so the parents or the children must be agreed lah.
I see.
Ha.
Okay.
Okay, all right. So another different, if without will, there is some possible disharmony, like the multiple owner for one asset. Let's say the property, we already know the entitlement according to the distribution at half will be going to children, and then quarter will go to spouse, another quarter will go to the parents, the Mr. A's parents. So if let's say Mr. A's parents pass away, so the portion of that 1/4, if they did not have the will writing, so it will be also distributed according to the Distribution Act 1958. So means that they will distribute the portion to their children also, which is Mr. A's sibling. So you can see that you have a different different owner for the one house. So with the will, actually, we and the trust will avoid the multiple owner of the asset and keep the asset safe within the Mr. A's family. And one of the tips, reminder need to let all the testator who write their will, you must keep the asset list up to date, because if you did not keep the asset up to date, the executor may need to locate the document and the information. Okay, the next scenario is on the Muslim scenario. So let's say a Muslim scenario with 3 children, and one of it is the adopted child. So Ahmad's family, they have 3 children here, 2 sons and 1 daughter. So the family also build out the asset. They have the residential asset, investment asset, car, and then liquid asset like cash, ASB, double haji, or unit trust, share. Okay, and then there is also the EPF funding. So if the Ahmad did not do any wasiat, so of course it will follow the Faraid law. So Muslim estate distribution, it will depend on what is the situation. Then only they will identify who is the legal A, then the portion entitlement. Let's say this situation, Ahmad, husband died leaving child, so the wife entitlement will be 1/8. But how about the children? So from here, you can, using one of the calculator, Paparan Jadran under this website. So from here, Ahmad, 1 wife, 1 son, and 1 daughter, because one of the son is the adopted children, is not the legal A. So from here, you can see that the entitlement is wife is 1/8, and then the son with the 2 portion from the daughter. Okay. So what is the Ahmad's wishes and concern? So Ahmad actually would like to have the residential asset distribute to the wife and also the son, and those investment asset to distribute with the wife to share, and then investment asset also have distribute the balance to the wife, son, and daughter. And he would like to give some gift to adopted children for the car and also some liquid asset. He would like to do some charity donation also. And the EPF funding, he would like to nominate the wife as the nominee and also the executor. So his concern also, if that happens, he still have the minor children, and then how he can take care of the adopted child's right, and intended to donate to the charity organization, and how can he protect his wife's right on those property owned together. So for this one, we also have recommend that the tools that he can utilize is like Awasia. From the Awasia, he can solve the issue of who to distribute. He can distribute a list of assets to his intended legal beneficiary, like wife and children, the percentage of the distribution. He can appoint the trustworthy personal or trustee company as the executor, appoint another substitute guardian who trustworthy to take care of the minor in case of the double tragedy happen. So he can also able to hiba the percentage of his investment value for a charity organization. So he can do the harta sepencaran with the wife to protect the wife's right to claim for the asset. Hiba, he can hiba those car to the adopted child, and also he can use the takafu policy as the hiba for adopted child. Even though for the liquided asset, he can also done the hiba amana to certain percentage of the investment value for the adopted child. Okay, so another one is that also encouraged to set out the trust, can fund the trust by own asset or via the takafu policy. This is because if there is the event of death happen and the children still minor, you can protect the minor children education funding, and also to taking care of the family living expenses. If during the lifetime Ahmad have in the situation of coma or disability, trustee also can taking care of the medical bill. Okay, for the Muslim couple with the 3 children, okay, let's say in the event Ahmad died leaving behind his wife, son, and daughter. We already know that for the faraid, the portion is like this. So if Ahmad also had the wasiat, so will Ahmad's last wishes be accepted or the faraid system will be override? Here, if all A agreed and said, yes, let's follow the father's last wishes, distribute according to based on the wasiat, then the distribution actually can proceed according to the wasiat. And take note that the agreement among the A must come after the person's death. Based on Amarah Raya experience, usually even if one family member disagree with the wasiat and insists on collecting his portion under the faraid, the other distribution actually would still go along with the wasiat. So under the manner of the Islamic wasiat distribution, they actually have 3 methods. The first method, they can go with 1/3 under the wasiat and 2/3 under the faraid. Or the second method is all go with under the faraid distribution. And method 3, you can go all under the wasiat distribution, provided the beneficiary status in the wasiat agreed upon by all the faraid A. So the last scenario is what happens if single with sibling only. So non-Muslim single with sibling. So single, you also will build out your asset, like EPA contribution, the funding, you have property or car, cash, investment, like share, unit trust, gold, others, and jewelry or insurance policy. If you are single and with sibling, right? So according, and you did not do the will. So according to the Distribution Act 1958, the following persons are entitled to the estate in accordance with the priority of. First will be the sibling, brother and sister. If in your family tree there is no brother and sister, then they will trace the grandparents, uncle and auntie, great grandparents, great uncle and auntie, and all did not have, then the finally will go to government. So in this case, for single, actually it's still advisable to utilize the will to protect your asset. You can distribute according to your wishes. That is to sibling or to some niece, nephew, charity organization, donation to school, orphanage or religious purpose. You also can solve the execution concern. If you don't know who to appoint, you can appoint the trustee company as the executor. So nomination, update the EPN nomination to nominate who you want to give, and also update the nomination in the policy. To set up the trust, fund the trust by own asset or via the insurance policy. For this case, you are single, you are also need to taking care of your well-being. If there is the cases of illness, then those policy assigned or the asset that you assign under the trust, the trustee can use those to pay for your medical expenses and also to manage your retirement fund, and also you can set it for charity purpose. Okay, summary here. Let's see what is the objective of the estate planning. Let us recap. So it's actually for the objective is to ensure that the maximum value of the wealth is distributed to your dependents according to your genius wishes, and to prevent the leakage of your asset to the government and others in the form of taxes and administrative charges. So one of the benefits if you do your proper estate planning, like writing your will, set out your trust, and done your nomination and hibah your asset, so at least you reduce some possibility of future disharmony and resolve the difficulty in dividing the property for distribution. You will not have a multi-owner of one asset. So provide for minor and the children with special needs like OKU, and provide for the aging parents, and keep your assets safe, and ease the burden of your family to go through the estate administration process. Okay, so that's all of my sharing tonight. I will pass the back to Kai for the Q&A section. Thank you.
Okay, thank you, Angel. Thank you, Eyvonne, for the sessions. It's a really an eye opener, for me, and I hope for our audience too. Here, we get to know how much it is very important for you to prepare yourself, for your will, for your wasiat, so that there is one point that Angel stated in the previous slide is to ease the burden of your family, so that after you pass away, you leave this world, your family are not burdened by are not burdened if you are not making the will or the wasiat. So okay,
the legal process.
yeah, the legal process is very complicated, and
Yes.
I believe that it will take a longer time if the previous step are not taken. Yeah, that's right. Okay. Okay, let's not delay our session tonight. So we move on to our Q&A. So okay, we have our first question from our audience, from Rasida Ahmad. So her question is, hibah for mortgage must have will or not? So okay, who want to answer this? Eyvonne?
Okay, I think what Razida meant is the asset. Okay, hibah for if you have already hibah an asset, then you don't have to put it in your wasiat. Okay, so like I said just now, 1/3 is to wasiat out, then the rest you can actually use hibah or follow the faraid law. Okay, so any assets that already hibah out, then you do not need to put it inside your wasiat.
The things that you want to hibah the asset must be clean asset, no mortgage one. If there is the outstanding
What do you mean? What do you mean by clean asset? What do you mean by clean?
Without any debt,
without any debts, no loan. Yes. So if your property is, for example, like what she said, mortgage is a house, you have alone. You
I
cannot
see.
bar that asset.
Okay.
Mm.
All right. Okay. Our second questions for tonight. From Razidah too. So, will administrator must be a lawyer? That is common among people, among Malaysians. So, what do you think about this?
Okay, let me explain for this one. Administrator actually is not the lawyer. It must be among your beneficiary to appoint. Lawyer actually is inside in the legal process. You still need a lawyer to help you to do those transfer. A lawyer will be involved, but lawyer actually is not the administrator.
Okay.
The administrator must be your beneficiary.
So, cannot be other than, so cannot be the outsider lah, you are saying.
Okay,
Yes.
can I add on something? So actually, you can appoint anybody as an administrator. So it doesn't have to be necessarily a lawyer. A lawyer can only help you, to get the grant of probate or, a letter of administration, because that he has to go to the high court to, do the process. So that you require a lawyer to do that. And also to transfer your assets, you need legal documents, then you need a lawyer. But the administrator is the person who help you, to gather all your assets, with the grant of probate or LA, to go to the banks or to other investment company to unfrozen all these assets. Okay, and then after that he has to, pay all your debts. Okay, then only he can distribute to the beneficiaries. So you have to appoint a person that you trust, okay, to become an administrator, not just somebody.
I see.
Mm.
Okay. So must be someone that you are close before. Okay. Okay. Next question. So from Kin Hoishin Vivian. Okay. Her question is, may I know if a person is a single mother with 2 minor children and the parents is financially depending on them too? So what estate planning tools can you recommend for them?
Okay, so the person is a single mother with the 2 minor, and parent is financially depending. Okay, this one can using the combination. It can using the will also, and also set out the trust. Okay, the reason of the trust is because if there is a event happen, triggering event happen, like death or coma or disability, then at least that someone professional can handle the funding, to give to the funding to the parents and also the minor children.
Okay. All right. So I hope that answer your question, Vivian. Okay. Next questions. Okay. So this is all right. So when do I need a will?
Okay,
When
I'll
is
take
the
this.
right time?
Okay, actually, a will is helpful whenever you have assets, okay, that you want to pass to a certain person. So you don't need to have like a certain amount of assets or wealth to use a will. So with the will, it can also, the process of asset administration, it can be faster and then less hassle, if you compare without a will. So it's not necessarily, you only had certain assets, then you want to write your will. Do I answer your question? So it's actually everybody, I would say, I would advise you to, write up a will, especially those who have minor children, aging parents to take care.
Okay. So okay, the next question, I think this question actually closely related to the previous one. So when should I set up a will? So for example, maybe someone young age just started working, so around 25, 26 years old. So should they started drafting their will, even though they don't have that much asset yet?
Okay, actually, it's never too early to set up a will. Even if you are like what you say, 25, 26. Uh, uh, as long as you have certain, you have assets and you want to, distribute to somebody, designated somebody, then you should write up a will. And there are many legal, professionals that recommend setting up a will now. Why? Because we will never know, what might happen and when we will need it, isn't it?
Yeah, that's true.
Yes. Yes.
Okay, we have another question. So, all right. So this one is, who should I tell about my will?
Angel, you want to take this?
Okay, can. Who should you tell your will? Of course, when you set out your will, first you will appoint an executor. So executor is the one that actually you need to let the executor know, because once it triggering event happen is the death occur, executor is the one that who will help you to do the execution. Another one is your beneficiary or your next of kin. They must know, you inform that, I have set out the will, I have done some of the distribution, so make sure you know that where my will putting. If not, if you pass away, nobody know that there is the will in place, then you may like you do the will, but nobody know. It shouldn't be lah.
Yeah.
It's as good as no will, like
Ha,
nobody
yes.
locate your will.
Yes, yes. Okay. And you also may tell a lawyer or any person that responsible lah for helping you to manage your asset one lah.
Okay, so from what I can gather here is, if you're starting to make your will, then you should tell your immediate family. Immediate family is okay to write. And then
Yes.
if you have spouse or if you have parents or other
Mm.
siblings, then you can also tell them about your will.
Yes, yes, especially the executor. If not, then who
Mm.
they don't know who will be execute your will.
Yeah.
Ha.
Okay. All right. So okay, the next one is, when execution of will, is all the asset need to transfer under executor name.
Okay, for execution of will, when in the legal, in the whole process, administration process, once they grant the probate, so the executor actually need to go around, just like just now the administrator lah, they will go around the bank, the asset, all this one, they will all transfer under the name of the executor first, because he have the responsibility to pay off the debt and also the tax before he can do the distribution. So everything will need to transfer under his name first. So the executor or the administrator is the very important personnel. It must be trustworthy. If not, you can imagine everything will be under his name first. Then pay off everything. Then the balance, he only can start to do the distribution to the beneficiary.
Okay. All right. Thank you, Angel. So okay. Next one is, any asset can be assigned under trust. What kind of asset can be assigned under trust?
Mm, okay, so like just now my sharing that the fund can assign under the trust either using your own asset or via the policy, which means let's say you have some liquid asset, cash or investment, then you can assign to the trust that you set out for the purpose of, let's say, the education funding or medical. Okay, so that is the one that you can put in. And also property, but the property assigned into the trust, it must be free of debt lah. Okay, if you did not have those resources on hand, then what you can do is that assign the insurance policy inside the trust. So when the triggering event happen, then the trust fund, the proceed can be utilized in the trust. So means that the summary is that you can any asset, cash, investment, or property. Property must be free or debt. And another option is using the insurance policy as a tool.
Okay. All right. Okay. Let's see if we have other questions from our audience. So, okay. Okay, I think we are coming towards the end of our session tonight. So before we end this session, so I would like to make some announcement. So this is a latest campaign from Vantage Advisory. Currently, right now, we are having this financial health check campaign. So this financial health check campaign, we are providing face to face, or in the current situation, most probably in using the virtual meeting, one-to-one financial consultation with our licensed financial planner. So this financial health check campaign comes with the financial report at an affordable price, which is 330 ringgit. These already include the SST and administration fee. So the benefit of this campaign is you can learn about your cash flow and your financial health. You can also get your customized financial plan created just for you. And then you can find out your key financial areas for improvement. So how to join this campaign is you can register at the link there, or you can scan the QR code. So later, after this session ended, I will share this poster and then also the registration link. You can register there. About the payment, is optional, whether you want to pay first and then you meet us, or you feel that you need to know more about the campaign. You can also register first, and then our representative will contact you for further arrangement. Okay, that is about our financial health check campaign. So another one is about our next webinar. So this webinar is about the estate planning. For this one is for individual. The moderator will be me again. And then we have one of our licensed financial planner, Khairiah, and also Angel will also be coming again for this webinar. So the webinar will be going at the 16th of December instead of January 13. So we will post the latest poster after this, and we hope that you guys can join us for the next webinar session. So I would like to say thank you to our audience for coming to our session tonight. I hope that you can have as many benefits and new knowledge about estate planning. I believe that everyone would like to know more about the will and the wasiat writing. So if you have further questions about the topic, you can just comment in the comment section and we can answer them after this, or you can PM us at our DM, and then our representative will contact you for further details. So thank you, Eyvonne. Thank you, Angel, for joining us and sharing information and knowledge with us. So I hope that our audience can stay tuned for the next session after this. Thank you, everyone, and have a good week and a good night. Bye.
Thank you. Bye-bye.
Bye.